Good day everyone, good day sir. This is our report about 1987 Constitution after martial law. This discussion is about martial law under to the 1987 Constitution. After Corazon Aquino seized power in February 1986, she abolished the 1973 Constitution and replaced it with what she called the Freedom Constitution. This Freedom Constitution was a verbatim copy of the 1973 Constitution minus the provision on the Batasang Pambansa. The legislator then operating. By the virtue of the Freedom Constitution, Aquino vested in herself both executive and legislative powers, the same powers President Marcos exercised under the 1973 Constitution. From 1986 to 1987, Aquino ran the country under a one-woman rule system. It was a dictatorship, plain and simple. Did Aquino allies, particularly those from the LP, oppose Aquino dictatorship? No. In fact, historical revisionists in the LP deliberate avoid mentioning that Aquino once ran the country under a dictatorship identical to the one which they contribute to Marcos. Instead of calling an election for delegates to a constitutional convention which will draft a new charter for the country, Aquino created the 1986 Constitutional Commission composed of about 44 of her political allies and very close friends. In just 5 commissioners from the political opposition, allies, and very close friends, the political opposition then led by ex-Labor Minister Blas Ople. Unlike in the 1934 and 1971 Constitutional Convention, which were opposed of elected delegates, every member of the 1986 Constitutional Commission was appointed by Aquino. Thus, for the first time in the Philippine history, the drafters of the nation constitution were not elected by people. Did Aquino allies oppose this unprecedented dictatorial move? No. The LP's historical revisionists are mum on this. The 1987 Constitution turned out to be a reactionary charter because its provision on the power of the president to declare martial law were diluted. In fact, its drafters publicly admitted that the charter is designed to prevent a rise of another dictatorship, akin to the under President Marcos. Just how dilute those provisions are will be revealed by a comparison of past charters with the present. The 1935 and 1973 charter vested in the president the sole prerogative to declare martial law. Congress had no power to interfere. Although the Supreme Court could review the validity of the proclamation of martial law, its power of judicial review was limited to whether or not the President acted arbitrarily in proclaiming martial law.
Are Congress and the Supreme Court equipped with enough information and expertise to decide if martial law is necessary for the country? On account of the lack of proximity, Congress and the Supreme Court have in relation to the source of the national emergency that is very doubtful. Whose decision prevail if the Supreme Court disagrees with Congress? That deadlock will surely lead to a constitutional crisis, and the nation does not need a constitutional crisis at a time when its very survival is at stake. What is constitutional crisis? Is a problem or conflict in the function of a government that the political constitution or other fundamental governing law is perceived to be unable to resolve. The crisis may arise from a variety of possible causes. Should Congress disagree with the President and revoke the proclamation of martial law, and it turns out that Congress is mistaken, then the state is needlessly compromised. Gambling with the nation's security at stake is courting trouble on a large scale. The other choice is a Congress to adopt the President's position and allow martial law to remain. If the majority of the House of Representatives belong to the President's political party, that is virtual certainty. Compared to the numbers of members in the House, the 24 votes of the Senate will not really matter in this regard. That's because the Constitution states that both houses of Congress must vote jointly in its deliberation on the President's proclamation of martial law. To all intents and purposes, therefore, the participation of Congress in the martial law equation is insignificant in the light of political reality. Jurisprudence under the 1935 and 1973 charters indicate the Supreme Court may disallow the proclamation of martial law only if the President acted arbitrarily in resorting to martial law. The reason for this standard is anchored not only on the principle of separation of powers underlying the Constitution, but also because the Supreme Court is not equipped with the knowledge and expertise on matters affecting the national security, at least when compared to the executive department. Under the 1987 Constitution, the Supreme Court is required to go beyond the arbitrariness standard and look into the factual basis for martial law. Can the Supreme Court really comply with this standard without knowledge and expertise required for doing so? The Supreme Court has since time immemorial ruled that it is not a trier of facts. At the end of the day, whether President Duterte likes it or not, and unless 1987's Constitution is so amended, and for the information of Vice President Robredo, martial law under the current charter is not the one-man rule. Robredo erroneously wants the public to fear. Arbitrariness means, when used in reference to a judge's ruling in a court case, arbitrary means based on individual discretion rather than a fair application of the law. Example of arbitrariness: finding someone guilty of a crime simply because they have a bird would be an arbitrary decision.